Good morning, everyone, on this rainy morning here in November. Welcome to our monthly webinar for CTR, where we talk about compliance issues. We're going to try to look a little bit into a crystal ball right at the moment and talk about 2025 and what we expect to see given the election and a few things like that. For those of you who know me, you can tune me out for the next couple minutes here, but these are always recorded, so you can look back at them later. The recordings are sent out to everybody who has sent up. There's like a link. Please give us about 24 hours to do that because it takes a little bit to download this and then send it out. For those of you who don't know me as well, I'm Ann Lavelle. I'm the compliance specialist for CTR. And prior to this life, I spent about 25 years as an attorney practicing management side labor and employment law for a very large firm downtown. I retired because I'd had enough. No, I enjoyed the work, but I wanted to spend more time with my family. It was a very demanding career, and I always enjoyed doing the training. So I love doing this type of thing and enjoy doing it for CTR. I'm a very casual speaker. So if you have a question, I'm not good with technology, but if you have a question, please put it, I think it's in the chat, maybe the Q&A, wherever it allows you to put the question. I'm happy to answer those in real time. It's a better learning experience for all of us if you submit questions, because if you have the question, I'm sure everybody else does too. Also, if you have ideas for future webinars or seminars, because we do a couple of live seminars throughout the year, please put that in as well, or send it to your CTR rep or the email at the end of the slideshow, and we'll try to address those because we want to make these relevant to all of you who are attending. So we welcome the ideas. All right, so where are we going today? This is sort of our agenda. We're going to talk about the political landscape from an employment perspective. And then we're also going to briefly revisit what the major laws, court cases, legislative initiatives were over the last year and how those are probably headed into the future. So again, feel free to ask questions as we go along, and we'll dive right in. So first thing I want to make clear is I am not taking sides in the past election or in politics or anything else. I'm merely trying to say, hey, we know historically, or we know based on comments that have been made, that likely what's going to happen. Okay, somebody just texted or chatted or entered a Q&A, I guess it is, that says the attendee chat is disabled. The Q&A is working though, so please put any questions there. And I apologize, I'm not good with technology. Like, I've broken my computer a few times for CTR. So in any event, please put your questions in the Q&A. So that is working, and so that'll be the format that we use that. Thanks for pointing that out to the attendee who mentioned that. Much appreciated. All right, so not taking sides. Nothing that is said here is meant to endorse anybody, anyone, or any party. We know that President-elect Trump's stance is overall less regulation. Let's talk about that for a second. So I think what a lot of people, and I certainly never realized it till I became an attorney, is that you have a law from Congress that is, maybe 20 pages long. And it doesn't address all the possible permutations and things that could happen with respect to that law. And so the agency that is tasked with enforcing that law comes up with regulations. And those regulations obviously are not passed by Congress. And this will become very relevant as we talk about a Supreme Court case as well here. Those regulations are not in any way blessed by Congress or passed by Congress or signed by the president or anything else. And the amount, it's called the Code of Federal Regulations, CFR is where it's at. And those regulations, if the law is 20 pages, the regulations might be 200, 300 pages. It's amazing how dense those regulations are. And if you've ever looked at, and probably most of you have never been so bored to do this, But if you've ever looked at the CFR, the Code of Federal Regulations, it's enough volumes to fill multiple library shelves. I'm old enough to remember when the CFR was published in books. It still is, although most people use it online these days. But it's truly amazing, the volume there. And that has been an issue for the courts, and it's been an issue for President-elect Trump. And he's basically saying, hey, too much regulation. You take a law that says ABC and you're adding to it, and you get XYZ plus, 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 and you end up with hundreds and hundreds of pages of regulations. And I'm sure all of you as HR professionals can identify with the fact that it's tough to comply. Like, you may have the best of intentions, and it's tough to know all of the regulations out there. It's tough to comply with them. They don't answer all of the questions that you might have. It's difficult. So they're saying, hey, less regulation. These agencies, at least in President-elect Trump's viewpoint, have gone overboard to have thousands of pages of regulations for every topic. It's not realistic for companies or employers to comply with, and it's too much government interference. That's his stance. That's also, as we'll talk about with the Supreme Court case, an issue there. So one of the things that President-elect Trump and the Republican Party in particular focuses on is independent contractors. So when we have President Biden and the Democratic control of our government, their viewpoint, so President Biden, we'll just call it his viewpoint, the Democratic Party's viewpoint, is almost everybody is an employee. Everybody. And there's certain good reasons for that. It provides workers' comp, there's pay regulations, overtime regulations. Hopefully it prevents some employee abuse in the sense of taking advantage of them in terms of hours and wages and all that good stuff. The things the other way when we have the Republican Party in place. And this is really tough for employers who utilize independent contractors. It's critical for what we call gig workers. Those delivery drivers or whatever that Uber, whoever. I'm not cool enough, I guess, to know what all the gig workers are. But we saw under the first Trump administration, sure, lots of people can qualify as independent contractors. The pendulum's over here. Then we have President Biden's group who says, no, nobody's an independent contractor, or almost nobody is, unless they meet certain really stringent requirements. Now we're going to swing back where we have the opportunity to say a lot of people are independent contractors. They still have to meet certain criteria. But that's really tough for employers to keep track of this moving pendulum, depending on which party is in power, as to whether or not the folks that they use as independent contractors will qualify as independent contractors. And if you have quote unquote gig workers, that makes it even more difficult, because a lot of those workers want to be independent contractors because they want that flexibility. They don't want the 9 to 5 grind, so to speak, and they want that flexibility. So if you use independent contractors or subcontractors, whatever it may be, you'll see that the Department of Labor, who enforces that, will start being more lenient as to who they consider an independent contractor. That may be good for you for the next 4 years, but beyond that, we may swing back again, right? We just don't know where that's headed. So there's uncertainty, but we know that that's something that's loosening up. If you have any pending litigation right now about independent contractors or a DOL complaint about it, it may behoove you to take some time and let the new administration come in and then look at resolving that, because you may be able to resolve it under more favorable terms. So something to think about. What else has President-elect Trump proposed? Well, he has proposed that tips, if you have tipped employees, to make their tips free from federal income tax. That wouldn't affect state or local income tax, but he's saying, hey, let's make those tips free from federal income tax. What does that mean to you? It's something to keep an eye on. It may make tips work more attractive in a challenging labor market to recruit in the first place. There may be some practical issues here too, that sometimes tips aren't reported. And so maybe the government feels like, hey, we can't keep track of them anyway, so we're just not going to tax them. Whether or not he can push this through, who knows? But that is part of his platform, or part of his ideas is we're going to make tips free from federal income tax. More critically, to almost every employer out there, is he has a proposal to make overtime payments free from federal income tax. Couple of things to look at this. Again, that may make the labor market easier for companies that need employees, need to incentivize them to work overtime. Certainly it's employee friendly in a way too, because they're going to have more money in their pocket if they're working overtime, if he can push this through. It does not affect state and local income tax, obviously. So that may help both employers and employees if that actually comes into play. Again, these are proposals or ideas by President-elect Trump and his advisors and party. So we'll see what happens. One thing about the overtime, and this is just a good sidebar here to have, no matter who's in office, overtime at the federal level. So when we look at the Fair Labor Standards Act, is any hours worked in excess of 40 hours in a work week. And an employer is free to set that work week however they want to set it, right? It can be Wednesday through Wednesday, Sunday through Sunday, whatever you want to do. You do have to have that in writing somewhere, what your work week is, so that's important. If you have employees sprinkled throughout the United States, and this is becoming more and more common with workers who work from home and different things like that, some states, particularly as you move out west, have laws about overtime where more than 8 or more than 10 or more than 12 hours in a day constitutes overtime, or more than so many hours in a 48-hour period. So if you have workers, the laws follow where the worker is at, not where your company is. And if you have Ann Lavelle out in Colorado or California or Washington or wherever, you will definitely need to look at those overtime rules, because they're different and they provide more benefits than the federal FLSA. And there's no indication that overtime in those situations would not be taxable. He's talking about the Fair Labor Standards Act and more hours than 40 in a work week. All right. Prior to this election cycle, President-elect Trump had indicated back when he was debating in the 2020 election, I hope I can keep all my dates here straight, because it certainly has been a whirlwind of unusual things. He indicated support for paid family leave at the federal level. We don't have that right now. Right now, what we have is a hodgepodge across different states and different localities. And we have done in prior seminars or webinars a lot of discussion about the Allegheny County and City of Pittsburgh sick leave laws. And so we have issues or benefits, depending on how you look at this, at the local level. But he has indicated support in the prior election cycle where he lost, that he would support federal paid family leave. There is a lot of momentum, I think, towards that, and there has been historically. It just never has quite gotten through. It certainly is more of a liberal or democratic agenda, but it seems to be gaining more traction from both parties. And so we may see that come into play as well. President-elect Trump is definitely less union friendly, even though he had the support of some unions in this past election cycle. But he does support what's known as right to work laws. Pennsylvania does not have that. A right to work law is where even if a company has a union in place, it does not require folks to join the union. So here in Pennsylvania, we don't have that. For most companies, if they have a union, you can require people to join the union in order to work for you, with some government exceptions. And there's some political exceptions too, but more or less that's the case. So there's no federal law right now for a right to work. There could be under him. So if you have a union, that's something to think about. He already has indicated that he's putting in place what I would call employer-friendly appointees to the Equal Employment Opportunity Commission, the Department of Labor, and the National Labor Relations Board, which if you're not familiar with the NLRB, you're probably familiar with the first two. The NLRB is what handles union and organizing issues. So what does that mean if you have an employer-friendly appointee? They're going to instruct their investigators from the top down on issues like the independent contractor saga to say, hey, it's no longer a priority item, right? They list their priority items every year. No longer a priority item. We're not enforcing it with the oomph that we did in the last 4 years. And instead, we're going to focus on something else. Historically, what they have focused on is training for employers, resources for employers, to provide them with more tools to hopefully comply with the law rather than focusing on enforcement actions after the fact. So we'll see what happens, but historically that's been true when we have employer-friendly appointees at these agencies. Minimum wage, again, if we go back an election cycle, President-elect Trump, when he was running back then, so this is the middle election, for those of you following along, signaled he's open to a $15 an hour minimum wage. During this election cycle, he had no significant comment on that. So it's hard to say where that will end up, but we know at least historically he was okay with a $15 minimum wage on a federal level. We already have that in some states and some localities, which again, if you have employees sprinkled throughout the US, that's something to look at, especially if they're working from home. If I'm in California, if I'm in Los Angeles, it's even higher than $15 an hour if I'm an hourly employee. All right, healthcare. President-elect Trump has historically and in this election cycle indicated that he wants to repeal the Affordable Care Act. That is a challenge, I think. So far, none of the court decisions have substantially dinged the ACA in terms of being a law. None of them have repealed it. None of them have said it's illegal. There's been nothing substantial against the ACA. And I think it's tough at this point because people are used to it. It's been around for more than a decade at this point to do that. So he may recognize that as well because he has an alternative plan, which is to place folks who have pre-existing conditions, who tend to be very expensive on health plans, into a separate pool of some type for insurance. I have no idea how that is going to work, but that is something that at least he has said to float the idea so that if you have Ann Lavelle and Ann Lavelle's had a liver transplant or something, I always pick on myself. I have not had a liver transplant, but I have some major condition and I'm going to be super expensive on your health plan and run up those costs. The idea is you take me off the plan, you put me in a separate pool. I really, again, don't know how this works because that pool would be super expensive for whoever's footing the bill for that, whether it's the employee, the employer, or some third-party government agency. It will be very, very expensive. But that is an idea that he has floated out there that if he can't repeal the ACA, that will put folks who are expensive in a pool of some type. Interestingly, though, he is supportive of the idea that insurers should pay for IVF. And so that's in vitro, right? To conceive a child. And most insurers don't pay for that right now. There are some exceptions, like Massachusetts, I believe, requires it. But for the most part, insurers don't pay for it. It's extremely expensive. Most people can't foot the bill themselves. He supports the idea of requiring insurers to pay for it. Whether that comes to fruition, who knows? But obviously that would affect some rates and premiums if that gets built into our health system, that's a requirement. Okay, so that's sort of where President-elect Trump is at on his agenda. He has lots of agendas, but that from an employment perspective is where he's at. And we're obviously not here to talk about the other agendas that might affect education or firearms or whatever. Okay, so let's talk about significant Supreme Court cases. So the first I want to talk about is a phishing case. And probably all of you are like, wow, Anne's really gone off the deep end this time, because what in the world does a phishing case have to do with employment law? This was a milestone case this past year by the Supreme Court. And it not only affects employment law, it affects literally everything that is out there in terms of um, anything that has regulations. So remember, I said we get laws and then we have thousands of pages of regulations. It takes up multiple library shelves. This case addressed that issue. Pardon me. So in Loper Bright, what happened was the department within the government that's in charge of maritime fishing made a rule. In other words, they made a regulation. And the way these regulations get made is that they publish them in what's known as the Federal Register. They invite comment from anybody who's impacted by the regulation. And then, in theory, at least, the government reads those comments and considers them, whatever agency is in charge of this issuing this regulation. And then they issue what's known as a final regulation, and they address the comments or the majority of the comments that they've received, and they explain why they either accepted the comments and changed the regulation, or they rejected the comments and they explain why they rejected it. So Loper Bright, the agency in charge of maritime fishing, issued a regulation with respect to certain certain fish that were overfished and might be endangered, that companies or individuals, didn't matter, who engaged in fishing for these overfished fish had to have an observer on their boat. And the observers were quite expensive, a couple $100 a day, to ensure that the fishing vessel was not overfishing the fishes that were overfished. Any event, that made, for most, especially smaller, fishing employers, companies, whoever, it was not financially feasible to say, hey, I'm going to spend a couple $100 each day to have an observer on my boat for a certain number of hours each day, because the amount I earn from fishing these fish doesn't offset having an observer. I can't make money, right? So I can't, you've just taken away my livelihood, because I can't possibly make money by having an observer. And so these fishing companies got together and sued and said, hey, this is an unreasonable regulation. It's not what's anticipated by the law. Sure, we want to protect these fish, but this is beyond what Congress intended when they passed laws about endangered species. So the first couple of courts, because it takes a while to get to the Supreme Court, said, we give great deference to the agency, the federal agency that issues these regulations, and we bow to their interpretation of the law. And yes, I really do have a point in all this. We bow to their interpretation of the law. And so these regulations stand, and sorry, little fishing companies, too bad if you've been put out of business and your livelihood that has been in your family for generations is gone. This is the law. These are the regulations. You have to follow them. And that is what we call the Chevron doctrine. If you've ever heard somebody say the Chevron doctrine, that is a law or a principle that says, that was announced by the Supreme Court back in the 1970s, that says we will always give deference to whatever the agencies put in their regulations, unless it's really, you can't support it by the underlying congressional law at all. And almost all the regulations you could support with the law in some way or shape, even if they were kind of onerous like this. So we have a new Supreme Court that's highly conservative, and again, not taking sides, whether that's good or bad, but they looked at this and they overturned the Chevron doctrine. They said, hey, we're not going to allow unfettered power, essentially, or almost unfettered power by these government agencies anymore, whether it's the fishing agency or the EEOC or the DOL or the NLRB or any other agency that you want to point to that's a federal agency that may impact your business or your personal life. We're not going to allow them to have unfettered power anymore. And we're not going to bow down to their regulations and assume that they are reasonable and supported by the congressional law that underlies them. Instead, we're going to look at them sort of anew and say, hey, does this make sense? Is it reasonable? And in this case, in Loper Bright, besides announcing this new standard that impacts every agency and every regulation across the board at a federal level, the Supreme Court said, hey, this is not reasonable. This is not what Congress intended, to put people out of business who are involved in fishing for these little fishies. They intended to protect species, right? We don't want anything to go extinct, but having an observer that costs more than the revenue generated by fishing is inherently unreasonable and not appropriate. So we've got a Supreme Court that is not in favor of regulation, and in fact has now issued a landmark decision that affects every federal agency to say, we are not just going to accept federal regulation. You, the federal agency, have to prove to us that this is reasonable and appropriate given the congressional law, and that we, the courts, are now going to be the arbiters of what is reasonable under the regulations. This tracks very nicely with President-elect Trump's promises to deregulate, because he's saying, hey, too much regulation. The Supreme Court is on board with him of saying too much regulation that's too onerous and outside the scope of what the original law from Congress intended. Now, that may impact us on the U.S. Department of Labor and the concept of what the salary threshold should be. We all know it got raised this year. It's about to get raised again. We'll talk about that in a few minutes. Whether or not that will withstand a challenge at the Supreme Court, whether that's going to be a reasonable regulation according to the court, is up in the air. And certainly employers have a lot more firepower now to say, look, that goes beyond the scope of the Fair Labor Standards Act, which is the law passed by Congress, and therefore Congress needs to raise the salary threshold, not the Department of Labor. And there's nothing written into the FLSA that says, hey, every 3 years it ought to go up and it ought to be tied to a financial metric for the sort of the least wealthiest part of the US and different things like that. It is uncertain where Trump stands with respect to the recent salary increase under the FLSA. When he was last in office, he did not support the raise that President Obama had put in place. And he withdrew support for it, which meant that they no longer, the DOL no longer actively advocated for it in court. So that raise went out the window for the salary threshold. We're positioned a little differently here. Tough to say what would happen. It's definitely worth watching, though. All right, if I probably bored everybody to tears with that long explanation, but if you are looking at this from a legal standpoint, I cannot tell you how important that case is to everything that goes on at a federal level. In Muldrow versus the city of St. Louis, Muldrow was a police officer. So we'll move on to this because this involves Title VII, which is an EEOC enforced law that talks about you can't discriminate, right? Can't harass, you can't discriminate based on any protected class. Makes sense. Muldrow alleged that she was transferred to a different position that essentially was a loss of prestige for her in retaliation for complaining about discrimination. She was, I believe, African-American. Her pay, her benefits, everything else was pretty much the same. Her hours varied a little bit, but more or less, she didn't suffer any financial harm from this move. And of course, the city had a reason that it articulated as to why it did it, that they said was non-discriminatory. More importantly, the city said, hey, she hasn't been harmed, right? There's no financial loss to her, no benefits loss. She's still got her uniform. She's still got her car. She's got like everything she had before we made the transfer. And the Supreme Court, and the Title VII actually says the employee has to suffer quote, significant, close quote, harm. And so the city said, hey, there's no significant harm here. And in a win for employees, the Supreme Court said, and this is a conservative Supreme Court, the court said, yeah, there's significant harm. Loss of prestige is enough for a Title VII claim. So may not have impacted her salary, may not have impacted her benefits, but simply transferring her from position A to position B, which she viewed as less prestigious, that's a factual issue and will allow her case to go forward, because loss of prestige in a job is theoretically significant harm. So something to be aware of if you have employees and you have an issue with one, that a transfer, even though there's no financial harm, may trigger a Title VII lawsuit. Okay, let me just keep going here. Let me just check the chat here. One moment. Get my little cursor over to the right screen here. And my cursor, that's good. One moment, let me just try to get over here. So we did get a question here, and the question seems to be surrounding, let me see, the FLSA. Okay, I will get to the FLSA in a second. Yes, the FLSA salary threshold went up July 1st for exempt employees. And remember, it's not just paying, well, here we are on the screen anyway. It's not just paying the salary threshold, it's also the duties test, which we have to keep in mind is somewhat confusing and difficult to interpret and understand sometimes. But it's not just paying somebody a salary that's a set amount. And yes, it did go up, and it's about to go up again in January. But if you don't pay the salary, the person is automatically non-exempt. It doesn't matter what their duties are, they're non-exempt, with a couple of exceptions for like highly comped employees and things like that. All right, so the FLSA salary basis increased, which we hopefully all know. It's going to increase every 3 years. It's tied to a metric in the Southeast involving a livable wage. And of course, the employee still has to meet the duties test. So something to keep in mind, this is now a moving target. It used to be that the DOL about every 20 years would set the salary threshold. And of course, that would, with inflation and the cost of living, would very quickly become outdated. And certainly by the end of like 15 or 20 years, it was outdated. Now they're saying, hey, every 3 years, we're going to update this. So it's a moving target. The courts that have historically blocked this type of increase, which are in the Fifth Circuit, which is Texas, and Texas tends to be kind of conservative. Nothing against Texas here. They refused to block it this time. So we've got this. President-elect Trump has been silent as to whether or not he would support this or not. So keep in mind, last time when he was in office, we had an increase courtesy of President Obama that was in the court system, just like this is kind of. This is still being challenged. And President Trump decided not to, again, we're going back. President Trump decided not to defend the increase. And so it basically went away. Whether or not that will happen here, I don't know. He is silent about it. We are positioned differently because back then the courts had blocked the increase. Here, the courts have already let it go and said, sure, that's fine. We also don't know if by the time this meanders its way up to the Supreme Court, which takes forever, what the Supreme Court will say, because we know the Supreme Court, with Low Fishy case, said, hey, we're not buying it. It's not, the regulation is not founded in the congressional law. So there is a lot of uncertainty about this right at the moment. The thing I would say from a practical standpoint is it's hard to unring a bell. If you have already given your employees these perks and these benefits, this increase, how do you go back to them and say, oh, you know what, the law changed, so now we're lowering your salary, or we're going to change you again so that you don't get paid for overtime or whatever it is. Very hard to unring a bell. So I think you proceed assuming this is the case, because that is the law of the land right at the moment. And I think you have to recognize that it's going to be extremely hard to unring the bell whenever we get a final decision on this law. or this regulation. Okay, moving along here. So, the FLSA tip rule for those of you who have tipped employees. So this is the hospitality industry. This was the other big thing that happened from a DOL, Department of Labor perspective. They had issued a rule. It was called the 80-20-30 rule. And what that essentially meant is that if I have a hospitality employee, like a server at a restaurant, that 80% of the server's work had to be directly involved in tip producing work. So they had to come over to Ann Lavelle's table, take my order, serve the meal, whatever. 20%, up to 20%, could be involved with what they call non-related tip work. So, rolling the silverware and the napkins or whatever it might be. And there was a 30-minute limit as well. So you had to sort of check all these boxes in order to say, I have a tipped employee under federal law. Fifth Circuit, again out of Texas, blocked this. And there's some debate as to whether the Fifth Circuit has the authority to block it nationwide, but that's their intent, is to block this regulation nationwide. The reason they blocked it, remember Lober Bright and those little fish? Well, essentially the Fifth Circuit said, hey, this regulation, which now the court is the arbiter of determining whether or not it's reasonable, we think it's not reasonable because if you look at the Fair Labor Standards Act and actually read the text of it, there's nothing in the text of the FLSA that talks about this test that they came up with for tipped employees. So in the court's view, the regulation failed because it wasn't reasonable. It went beyond the scope of the congressional law. And in fact, maybe contradicted the congressional law because the law, the FLSA, actually has a definition of a tipped employee, somebody who gets tips. Not a very complex definition, I guess, but it's been blocked on the federal level. But what about Pennsylvania? So for all you Pennsylvania employers out there, and I know that's the majority of folks on this call, we are in a conundrum. And really, if you have tipped employees, I would suggest talking to Labor and Employment Council. When the FLSA regulations and the DOL adopted this 80-20-30 rule, what did Pennsylvania do? We are a blue state, right? We jumped on board with this initiative and we said, hey, well, I guess we were kind of a red state last time. And again, I'm not picking, not doing whatever. We said, hey, we're going to follow the FLSA. So we adopted by reference in our regulations, in Pennsylvania, our regulations, we adopted the 80-20-30 rule. And we specifically said, Pennsylvania specifically said, our Department of Labor and Industry, we adopt the 80-20-30 rule as reflected in the Code of Federal Regulations. Well, now the CFR has been, the federal regulations have been blocked. The Pennsylvania regulations are still hanging out there. So what does that mean? Does that mean because we said, hey, we're following the federal regulations, that Pennsylvania doesn't have the 80-20-30 rule anymore? Or does it mean that we still have it because the federal regulations were blocked, but states are free to do what they want? This is different regulations, it's state-based regulation. There's a real question mark there. There's certainly risk there if you are a company with tipped employees and you don't follow the 80-20-30 rule in Pennsylvania. So it's something that I would encourage you, if you're in that position, to talk with Labor and Employment Council about the risk and whether or not how you perceive the Pennsylvania regulations at this point, because it's a very gray area and how it applies to you. I want to point out as sort of a sidebar here, this is a really common issue to have a disconnect between state law and the FLSA. And so we've covered this in other FLSA webinars that I've done, but it's worth repeating because it happens all the time and employers get caught on this all the time. The FLSA is a federal law. It does not stop states or localities, Allegheny County, Pittsburgh, Philadelphia, whoever, issuing more generous regulations or laws with respect to wage payment and employees, or different laws. And so what we see in Pennsylvania at least, is a disconnect in many areas between the FLSA and Pennsylvania wage law. And again, we've covered this more in other webinars. But for instance, we don't recognize the 8 and 80 overtime rule that's in the federal FLSA regulations for healthcare. We don't recognize the computer professional. Pennsylvania does not recognize the computer professional exemption that's in the FLSA. So you have to be very careful there that whatever exemptions you're looking at, whatever wage and hour payments you're looking at, you're following both the federal law and you've looked at the state law. And again, it's the state where the employee may be working. So if Ann Lavelle's out in Colorado, we got to go look at what Colorado has said in terms of wage payment, final pays, overtime, vacation, etc. Like some states like California, you can't have a vacation rule where it's use it or lose it. That's prohibited in California. It's perfectly legal here in Pennsylvania. It's perfectly legal under the federal FLSA, but not in California. So lots of disconnects between state laws and the FLSA that you really need to drill down into if you have employees, especially sprinkled throughout the US. Okay, moving along. We've covered this before, but it's worth hammering on again. So this is some interesting statistics. I can talk. We have done a couple of webinars about what the city of Pittsburgh and Allegheny County sick leave laws are, but I want to point out something about the city of Pittsburgh. They're being kind of aggressive in their enforcement. One interesting statistic on their website is they've had more than 500 employer leave policies submitted for approval, either because there's been a complaint or the employer is seeking sort of a blessing on their policy. And keep in mind, with these local laws, you can have a PTO policy that is meant to cover the requirements of the city of Pittsburgh or Allegheny County sick pay days outs. But it has to meet all the requirements of those ordinances. And that's the problem. A lot of employers have PTO policies. I just covered this. I just did a seminar for the Pennsylvania Human Resources Association. And we talked about this a little bit. A lot of PTO policies don't cover the types of leaves available under these local ordinances. They don't allow the time to be used in the increments, the small increments allowed by these ordinances. Like oftentimes PTO policies say, hey, it has to be at least half a day. Whereas these ordinances say the time is either the smaller of an hour or however you keep time for other leaves like FMLA. They don't cover the right relatives. So for instance, both of these ordinances would allow a person to take time off for their grandparent's partner, domestic partner. That's not true of the FMLA. That's not true of most PTO policies, etc. A lot of PTO policies require medical documentation if you're going to be out a certain number of days or whatever it is. Very limited under these ordinances when and where and how you can get information. So these policies are failing to get blessed, if you will, by the city of Pittsburgh because of those issues. And so while they've had more than 500 submitted to them, about 200 have passed muster. That's less than a 50% passage rate. That says to me that a lot of employers are submitting policies that are failing on those threshold issues of who you can use the time for, how much the time, how it accrues, etc. They also, City of Pittsburgh has what I call the website of the shame or fame, which they say it's a work in progress, and they haven't actually listed anybody on there yet. But they have a website that essentially promises to list the employers who exceed the requirement, right? So you could see your name in bright lights or your company name in bright lights on their website if you're doing really, really well. The companies that meet the requirements but don't exceed. And then the wall of shame if you have a situation where you are not meeting this correctly. And I just got a message that my battery is running low. If I somehow lose everybody, I'm going to apologize, and we'll continue next month in all of this. The city of Pittsburgh is focusing on the hospitality industry. I'm going to stop my video so I can look to see if I can plug this in somewhere. And that is difficult for restaurants and hotels and places like that, are being targeted by the city of Pittsburgh for random audits, not just complaint driven, for these issues. Keep in mind that this is an issue even for companies outside the city of Pittsburgh who, have employees who go into the city of Pittsburgh or Allegheny County, or who work from home there, in homes in Allegheny County or the city of Pittsburgh. Those employees are going to be covered by the law, even if your company is in Butler. Give me 1 second to see if I can't plug this in better. I think it came loose. One moment. My apologies. As I said, technology in me is not always a good thing. All right, I think I have us better now. Okay. It's always fun to crawl under a desk in the middle of a webinar. So, living the good life here. Okay, so as we move forward, let me get my cursor back to where it should be. We also had the Federal Trade Commission non-compete rule. So the FTC essentially said for for-profit companies, you can't have a non-compete except in very limited circumstances. And those limited circumstances involve situations where, like, the person was selling a company or they earn more than about $155,000 a year. So here we go again. Okay. A federal court did block that law that it was actually a regulation, not a law, nationwide, and said, again, we had the little fishy case, right? Essentially said, hey, FTC, you have exceeded your authority under the underlying laws that enable the FTC, and we're not going for this. It's been blocked. Now, it's still going to weave its way through the court system. While President-elect Trump has been silent on this, VP-elect Vance has signaled support for this rule as it applies to the tech firms on the West Coast, particularly. So it'll be interesting to see what happens. This moves this type of legislation to the state level. And you will find already some places like California prohibit non-competes or no poaching. That means I can't go steal an employee from somewhere else, or it means I'm prohibited from doing that type of agreement. So you do have to look at where you're located, the type of profession. So for instance, in Pennsylvania, attorneys cannot have a non-compete. Kind of interesting. You have to look at where the employee is as to whether you can even enforce something like this, but you're well advised, because this seems to be another one of those situations that it's a hodgepodge, to have built into any employment agreement. You have like this strong non-solicitation language and confidentiality, trade secret type of language, so that if somebody leaves and you can't enforce the non-compete for whatever reason, you're protecting your intellectual property. Okay. I just turned my video off again. Goodness, I'm having some technical issues here. Anywho, we'll see what happens with respect to that. I apologize, I've lost my cursor again. Can't get that, there we go. All right, we've covered this in other webinars too, but it's worth noting here that EEOC, the Equal Employment Opportunity Commission, has this as a hot button. Whether this will remain a hot button under Trump is anybody's guess, but the issue is they don't like artificial intelligence. They think it incorporates historical biases that include discrimination and antiquated ideas. And so this is a hot button enforcement item for them. They have said that they are going to, for this, even if you're using a third party, you're advertising your job and using some type of search engine on whatever website to get candidates, that this will look for that to see if there's historical bias built into that search engine somehow. And you, the employer, are responsible for that alleged discrimination, even if you've used a third party. So a little difficult for employers right at the moment to know exactly how that's going to play out, but that is a hot button issue for the EEOC right at the moment. Okay, other EEOC initiatives include guidance that says, and again, this guidance may go out the window because of the fish case, but right now they want employers to conduct what they call climate surveys in their companies. That has nothing to do with the temperature at the workplace. It has to do with anonymous surveys that talk about, hey, do you think there's discrimination or harassment here? And if so, where, who, what, when? They also want companies to provide training for employees on how to report and support victims. So in other words, I might not be the one who's being harassed or discriminated against, but I see that poor Joe over there is having things said to him, and so I should report it. That's what this training is all about. And then I should go support Joe. I'm not saying that's not ethical to do and not a good thing to do, perhaps, but the EEOC is looking for employers to do that as part of their training. And as a sidebar, this training on non-discrimination and anti-harassment should occur at least once a year, right? In some format, whether it's a live trainer or a video presentation. And of course, you should have the employee sign off on it. All right, other things that we're seeing in the workplaces, mandatory return to work. That's completely legal. You can require your employees to return to work with one important exception. You always have to look at whether or not there's a disability accommodation, and the number of disability requests to work from home has risen. We have proven as a society that we are capable of doing a lot of work from our homes. And so it used to be maybe 20 years ago when I was knee-high to a grasshopper that a work from home request for a disability was almost always denied because the technology wasn't there to support it. Now it is. So that's a serious request. If you say, hey, everybody has to return to the office a certain number of days or every day or whatever it is, if somebody says, I can't because I have anxiety, which could be a disability, we got to dive into that under the Americans with Disabilities Act and take a look at that. Employer culture is a hot button right now for employers because of the labor shortage, right? Everybody's looking for an angle to get that employee, whether that is wages and benefits, which helps, or we support a certain cause, we have a certain culture. You know, Starbucks has a very different culture than other companies, and that may attract people or not, depending on how they look at things. The other thing to keep in mind is that a lot of states are moving towards this idea of freedom of speech. That doesn't mean as an employee, I can just say anything I want. Instead, it's limiting employers' ability to talk to their employees. So it says essentially, hey, employers, you can't force your employees to attend a political meeting or a religious one. That's been true for a long time. Or an anti-union organizing meeting, which is really what this law is directed at. So when a company gets organized by a union, typically the employer has mandatory meetings for the employees to tell them why it's a bad idea to be organized by that union. Now the laws are saying, hey, you can't do that. Pennsylvania doesn't have this yet, but we do fall in line sort of politically with these other states that have done it. So something to keep in mind and think about. And certainly if you have employees in those states, you should know about this. You cannot discipline or incentivize them. So you can't provide that like free lunch or raffle for the $25 gift card or whatever it is to attend these meetings. Okay, we have wrapped up. If there's any last minute questions, please let me know. Otherwise, we're going to come back next month. We're going to talk about some additional issues going into 2025. I'm sure we'll have more by then. And happy to answer any questions anybody may have. Otherwise, take care on this rainy day. And thank you for attending.